Okay, ons is live. Okay, staan by op
The African Court on Human and People's Rights is now in session. In the matter between the African Commission on Human and People's Rights and the denied Zania albinism for the Honorable Dr. Matakala presiding.
Okay, staan by 3. Okay, let's gaan na jou toe Sean. Sean is live. Staan by 3. Ek het vir my klank check. Nou weet jy. Okay, ons gaan na 3 toe. Hy is live.
Good afternoon.
Okay, Sean.
Council will begin with
Okay, ons sê
an
Nederlands.
introduction.
Sean
We
het pas.
shall have an introduction of council for the applicant, and then followed by
Okay, Marlijn, jy gaan na mense
introduction
laat
of
volg.
respondent, and then we'll come back to the
Die ook al interviews.
introductions, please.
Staan by 3 en 3 is live. Okay, staan by Marlijn.
My name is Alvea Masanjala, counsel for the applicant.
Ja, ons gaan 3 toe. Marlijn, jy kan hier op bly, jy kan uit jou vryheid loop. Staan by Marlijn, Marlijn is live. Okay, en ons gaan right. Staan by Marlijn.
My name is Arojo Kalego, as counsel for the respondent.
Okay, ons is terug op right. Staan by Sean. Ja, eerst Marlijn.
My
en
name is
Marlijn is live.
Atin Okelo, second counsel for the respondent.
Thank you very much for the
Okay,
introduction.
ons is terug op right. Staan by Sean.
Counsel for the applicant, you may
Sean is live. Okay, staan by Marlijn. Eerst 3 toe. Dan doet hy ook, ja, hulle en Marlijn is live.
Good afternoon, Your Honorable Judges. As already introduced, my name is Alvea Masanjala, and I am counsel for the applicant. I shall take 15 minutes of this court's time addressing it on the first and the second issue, while my co-counsel shall take 12 minutes of the court's time addressing it on the third and
Marlijn is live.
fourth issue, and we reserved 3 minutes for the rebuttal. Zambia is a sub-Saharan country in Africa. It is a party to the UN Charter and the African Charter.
Okay, gaan
A
na
report published by the applicant in 2010 showed that Zambia has a higher prevalence of persons with albinism than other sub-Saharan African countries. The report also revealed that persons with albinism in Zambia
sien dat
have
baie
been
spesifiek
subject
is.
to
Dis live
insecurity
vir
in
baie
terms of
stadig
their
terug beweeg.
education and have also been subject to killing and mutilation. The applicant, in response to the report published by the applicant, state of Zambia started taking children with albinism under 10 and
Die
placing them
kamera
in
se
temporary
kan
shelters.
los.
The applicant
Description.
instituted a case
In the
before the
long
High Court of Zambia that appealed before the Constitutional Court. And
By
now
some
the
Johnson.
court brought the case before this court because it feels that issues were not
Okay.
addressed in the court.
Check it. Is it klank?
Your Honor,
We
I'd
did.
now like to give the layout of our case. Applicant has seized this court for the determination of mainly 4 issues. Whether the state of Zambia has violated relevant international human rights law in the following circumstances. Firstly, in removing children with albinism from their home, place them in temporary shelter. Secondly, in making these children go to school in the temporary shelter. Thirdly, in failing to bring the release and mutilation of persons with albinism to a home. And lastly, in promoting the genetic testing of OCA1. With regards to the issues of jurisdiction and accessibility, it is our submission that this court has jurisdiction. Because Article 2 of the African Court Protocol gives this court jurisdiction to rule over cases dealing with the interpretation of the African Charter and other relevant international human rights instruments ratified by the state. The state, according to paragraph 2 of the fact, ratified the African Charter and the African Court Protocol. The applicant has standing as the received observer stated in 2010, according to the facts in paragraph 4, and the state of Zambia, according to paragraph 2 of the fact, made a declaration under Article 34 to Article 6 of the African Court Protocol. It is also our submission that the facts of this case meet the disability requirements set out in Article 56 of the African Charter. With your permission, Your Honor, I would now like to move into the merits of our case. Much obliged, Your Honor. It is our contention that in removing children with albinism from their homes and communities and placing them in temporary temporary shelter, the state of Zambia has firstly violated their right to family protection and to be raised by their parents, and secondly, has violated their right to freely take part in the cultural life of the community and to be included in the community. Now, as with regards to the issue of family protection, Article 18 of the African Charter and Article 8 of the Children's Charter provides for the right to family protection. Article 17 of the ICCPR states that in order to ensure that there's protection of family, the state must ensure that there is no arbitrary or unlawful interference with the family. I would like this court to be persuaded by the case of Sudan Human Rights Organization versus Sudan, in which the African Commission held that forced separation of family members is arbitrary interference and is therefore a violation of Article 18 of the African Charter. The facts of this case show in paragraph 9 and 10 that these children have been removed from their homes without their consent to be put in these temporary shelters. It is therefore the applicant's submission that the state of Zambia is in violation of Article 18 of the African Charter and Article 18 of the African Children's Charter.
Counsel, does the state not have an obligation to ensure the right to life and the right to physical security of these children? And does the right to life perhaps take precedence in the circumstances to the right to family? If you could address the court on that, please.
Much obliged, Your Honor. Firstly, I would like to mention that all human rights are interdependent and indivisible. And the state does indeed have an obligation to protect the right to life of these children. But it is our submission that in interpreting what constitutes the right to life, the state must adopt a wider interpretation, as was adopted by the African Commission in General Comment number 3 on the right to life, which states that the right to life must be interpreted broadly such that for one to have a dignified life, there must be enjoyment of all the rights enshrined in the Charter. Therefore, it's our submission that the state should have adopted a wider interpretation of the right to life and should have also sought to protect the right to protection of family.
Maybe, Counsel, maybe to put it clearer, what should the state do in the circumstances where the communities are unsafe? Leave the children to live in unsafe community or find other ways to protect them?
Much obliged, Your Honor. It is our submission that according to General Comment number 9 of the CRC, the state has a duty in times of risk to remove perpetrators of violence from the community and not the children themselves, as opposed to so that the children can still enjoy their family environment.
You may proceed, Counsel.
Thank you, Your Honor. The applicant would like to submit that it is aware that the right to protection of family is subject to limitations, but these limitations must meet certain conditions that were set out by this court in the case of Konati versus Burkina Faso. And the conditions that are supposed to be met are that these limitations must firstly be prescribed by law, secondly, must serve a legitimate purpose, and thirdly, must be necessary and proportional. It is our contention that the limitation placed on the right to protection of family has failed on two of the three of these grounds. The facts show that the state of Zambia is relying on the fact that the children have been removed in accordance to the Children's Act of Zambia. But in General Comment number 16, the ICCPR said that arbitrary interference extends to interference provided for by law, if such interference does not meet the conditions required in international human rights law. These conditions are set out in Article 27, Subarticle 2 of the African Charter. Therefore, we submit to this court that the state of Zambia's limitation has not met the conditions set out in Article 27. The state of Zambia cannot prove that in allowing children back into their homes, it will adversely affect the right of others, or that it is contrary to public safety, or contrary to public morality, or against common interest. It is our submission that the state of Zambia has also failed in legitimate purpose. As I already said to this court, the state of Zambia is aiming at protecting the right to life, but it must interpret the right to life broadly so as to include the enjoyment of other rights. Therefore, in interpreting the right to life narrowly, the state of Zambia has also failed on the ground of legitimate purpose. Therefore, Your Honor, we submit that
that the applicant's limitation on the right to protection of family is unlawful. We also submit that in removing children from their homes, the state of Zambia has violated Article 17, Subarticle 2, which provides for the right to take part in the cultural life of the community. The state has also violated Article 19 of the CRPD, which states that persons with disabilities have the right to be included in their family. Article 19 of the CRPD goes on further to qualify that in order to ensure inclusion, persons with disabilities must be allowed to choose where they stay and mustn't be mandated to live in certain living arrangements. The facts show in paragraph 9 and 10 that these children have to stay in these living arrangements until the state can curb the violence. But the state cannot tell us when they can curb the violence, seeing as paragraph 7 of the facts states that the violence stems from beliefs deep-rooted in the communities. The state cannot ensure the children when it will be able to eradicate these beliefs from the people. Therefore, these children will stay in these camps for the unforeseeable future.
Council, what is the difference between integration and inclusive education? And if you can address the court on which one of the two the state has actually done.
Much obliged, Your Honor. When it comes to inclusive education, it means that the state if you'd allow me, Your Honors, I'd like to just firstly adopt the definition given by the CRPD on inclusive education, which the CRPD defined inclusive education in general comment number 4, paragraph 9, as encompassing transformation in culture, policy, and practice in all formal and informal educational environments to accommodate the differing requirements and identities of individual students. So, to put students in the same school and not provide for their needs is to not have an inclusive education. That would be an integrated education. If learners with albinism are in the same school with learners without albinism, but their needs are not provided for, that would not amount to inclusive education. I would now like to move on to our second issue, which is actually dealing with the right to inclusive education. We submit to this court that in making children with albinism go to school in temporary shelters, the state of Zambia has violated the right to education as provided for under Article 17 of the African Charter and Article 24 of the CRPD. Article 24 of the CRPD states that with respect to persons with disabilities, the right to education must include the right to inclusive education. Now, the creation of a segregated school system in which children with albinism go to school in one place and children without albinism go to school in another place is contrary to Article 24 of the CRPD. Even though the applicant is aware that the right to education is subject to progressive realization, there are still minimum core obligations that a state has to meet with respect to inclusive education. One of those core obligations is non-discrimination in all aspects of education. Now, it was said in general comment number 4 on the CRPD that the right to non-discrimination includes the right to not be segregated and to be provided with reasonable accommodation. In this case, the facts show in paragraph 10 that these children are being made to go to school in these same shelters away from other children, and therefore the state of Zambia is offering education on a discriminatory basis, contrary to the CRPD. The second obligation, the minimum core obligation on the state, is to provide reasonable accommodation in these schools. The state of Zambia has not done that and is therefore in violation of Article 24 of the CRPD.
Council, just to interrupt, it's worthwhile to hear the reiteration of the obligations of the state of Zambia. However, I need to hear from you, how do you interpret the principle of progressive realization in the context of a developing country like Zambia?
Much obliged, Your Honor. The concept of progressive realization is there to take into account the different economic factors or social and financial constraints that are on a country. Therefore, we understand the state of Zambia is indeed a developing country and therefore cannot be able to provide education to the fullest extent. This is why we submit to this court that the state of Zania should have at least fulfilled the minimum core obligations, which are provided for in General Comment number 4 on the CRPD. Those are minimum core obligations that the committee on the CRPD made, thinking of the fact that not all countries will be able to fully realize the right to education.
Could you remind the court of what those minimum obligations are according to General Comment number 4?
Much obliged, Your Honor. The minimum obligations are, firstly, to provide education on a non-discriminatory basis. Secondly, to make sure that there's reasonable accommodation to ensure non-exclusion. And lastly, to provide compulsory free primary education. The state of Zambia has only fulfilled one of the three.
Thank you.
Counsel, don't you think it was the safety of the children with albinism to be taken to the shelter?
Much obliged, Your Honor. I do recognize that in taking children with albinism to their shelters, the state of Zambia was indeed trying to protect their right to life. But we submit to this court that in taking children and putting them into temporary shelters, the state of Zambia was only looking at it in one way. The state of Zambia failed to consider all of the other factors that must go into making sure that a child can achieve holistic development. The state of Zambia was only considering their physical safety.
You obviously recognize that the state had an obligation to take into account the right to life and the right to physical security. Without the right to life, there can be no other right. Yet you're suggesting possibly that the manner that they've chosen to protect them is not appropriate. What alternatives could you suggest?
Much obliged, Your Honor. The CRPD committee suggested to the state of Kenya in a concluding observation, which I'd also like this court to note that the state of Kenya is also a developing country, much like Zambia. The CRPD committee suggested that the state of Kenya adopt strategies and policies to ensure the deinstitutionalization of persons with albinism. It also suggested that the state take steps in introducing specific budgetary allocations for the promotion of independent living of persons with albinism. Therefore, it is we submit that the state, in putting children with albinism into the shelters, for them it was the fastest and the quickest policy. They did not take into account other things, and that the state should have taken into account other measures, should have taken time to think of a strategy that can ensure that these children not only stay alive, but have a dignified life.
Counsel, I'm mindful that your time is up, but I'm also very mindful that we've asked you a lot of questions. So we'll allow you a minute to wind up.
Much obliged, Your Honor. In light of these submissions, I would like to submit to this court that the state of Zambia has violated Article 18 of the African Charter in right to protection of family, and is also in violation of Article 17 of the African Charter and Article 24 of the CRPD on the right to inclusive education. I'd now like to pass it on to my co-counsel.
Your Excellencies, good afternoon. As already introduced, my name is Kwima Mchizi. Within the next 12 minutes, I am going to prove to this court that in removing, in as far as the state of Zambia has failed to curb the violence or the killings and mutilation of persons with albinism, it is in violation of the right to life as well as the right to security of the person. And secondly, on the last issue, that in promoting OCA genetic testing, the state of Zambia is in violation of the right to dignity as guaranteed under the African Charter. I'll move on to make the prayers on behalf of the applicant. Your Excellencies, on the issue of the failure by the state of Zambia to curb the violence against persons with albinism, the first submission of the applicant is that the state of Zambia is in violation of the right to life as guaranteed under Article 4 of the African Charter, as well as Article 10 of the CRPD when it comes to specific guarantee of the right to life for persons with disabilities. Your Excellencies, I would like this court to be persuaded by the decision of the African Commission in International Pain and others on behalf of Ken Saro-Wiwa, where it was held, versus Nigeria, where it was held that the prevention of arbitrary deprivation of life is the principal aim behind the right to life. In the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe, the African Commission held that a state would be held liable of violating the right to life where it fails to exercise due diligence in preventing the violation of the right to life. Your Excellencies, I'll prove to this court that in 3 ways the state of Zambia has failed to exercise due diligence. Firstly, Your Excellencies, I'll take you to paragraph 8 of the facts of the case. And paragraph 8 of the facts of the case show that the state of Zambia is failing to effectively prosecute perpetrators of violence against persons with albinism. That failure is due to the fact that there are unwilling witnesses within the state of Zambia. However, according to the case of Paul and Audrey Edwards versus the UK by the European Human Rights Human Rights Court, which I would like this court to be persuaded with, there is an obligation for a state to actually compel witnesses where these witnesses are crucial to a case which involves violations of the right to life. And by failing to compel witnesses to come and testify in the trials where the state was prosecuting these people, the state of Zambia is failing in its due diligence principle. Your Excellency, secondly, within the same paragraph 8 of the facts, it is shown that the state of Zambia is not making reparations for persons, for the victims of the attacks and killings and mutilations. Your Excellencies, according to General Comment number 3 of the African Commission on the right to life, it is one of the things that is required under the issue of due diligence that a state is supposed to offer reparations where violations have taken place. And the state of Zambia, in not doing that, is also failing in its obligations under international law. And then lastly,
question, how do you deal with the problem of reparation in a context where people are being attacked? Do you think that it might be an incentive for people because some of the attacks can be carried out with the intent of family members carrying out the attack on their own so that they can get reparation as victims. Have you thought about the consequences of reparation being an incentive?
Thank you very much for your question. There is a possibility that there would be some bad apples, I think just like with any other principle. But then at the end of the day, it is the contention of the applicant that in providing reparation for those victims will get an effective remedy in the sense that in some instances, the violence that is perpetrated against those people might lead for some of them to lose their jobs. If, for example, a person with albinism has been attacked and they've been mutilated or they've been disadvantaged in terms of their work, Your Excellencies, they would need reparation so that they continue with a dignified life. So much as there would be instances in which there would be cases where some of that would happen, Your Excellencies, we still hold that the bigger picture would mean that the same would help in those families that are affected economically because of the killing, the mutilations.
How do you distinguish circumstances where state organs directly violate rights of persons? I mean, and another circumstance where, of course, like that one of Zambia, where violence is not committed by the state organs, but by individuals who simply believe in witchcraft. And of course, you cannot have a timeline within which people must stop to believe in witchcraft.
Much obliged, Your Excellencies. The obligations for states, for example, in terms of the right to life, is one of the obligations is to respect the right to life. And in that regard, the obligation is directly on the state to not violate the right to life. However, there is another obligation, which is to protect the right to life. And in this case, it is still the obligation of the state to protect its citizens from the acts of non-state actors. And according to the African Commission, Your Excellencies, in the case of Sudan Human Rights Organization and another versus Sudan, a state will still be held liable for the violations of non-state actors. And in this case, it is our submission that the state should still be held liable for the violence by non-state actors.
Yeah, maybe, Council, to clarify, under these circumstances, what should a state do in order to protect the lives of people who are being attacked by others who do believe in witchcraft?
Your directly concerning the issue of witchcraft, which is another limb of the issue that I was going to deal with. The state of Zambia has the Witchcraft Act, which obviously has been there since colonial days, which might not address the issues as of present. But apart from the laws that are there concerning the witchcraft, Your Excellencies, the issue of witchcraft is about beliefs, and therefore the state has an obligation to raise awareness about issues surrounding albinism, and then to combat the malpractices that are taking place within the state.
So do you believe that it is possible to have a time limit within which people will be aware that witchcraft practice do lead into violation of human rights?
Your Excellency, specifically there might not be a time limit, but the state has to be seen to be doing something towards realization of the rights of its citizens. So much as it cannot specifically say within the next 2 years there will be no more violations. Your Excellencies, the state has to at least do something in order to make sure that at least the views of the people or the attitudes of the people are changing as time goes by.
Thank you, Councillor. You have just under 5 minutes. If you may please proceed with your submissions.
Your Excellencies, further to the same, it is the submission of the applicant that the state of Zambia is in violation of the right to security of the person as guaranteed under Article 6 of the African Charter. Your Excellencies, in the case of Sudan Human Rights Organization, which I already cited, the African Commission held that the obligation on the state is actually to provide protection from violence, in this case against both the body, physical injury to the body, as well as injury to the mind. The obligation of the state concerns every person that is within its jurisdiction. And according to the Human Rights Committee in General Comment number 35 on the same right to security of the person, the state has the very basic obligation to ensure that its citizens, or in this case, all persons that are within its jurisdiction, live a safe life. Your Excellencies, if we go to paragraph 8 of the facts, there are killings of persons with albinism that is taking place within the state of Zambia. Some are being mutilated, some are being abducted, and in this case, children actually are being abducted. These people continue to live in fear, and it is the duty of the state, in this case, to protect these citizens on an equal basis with the rest of the population. The state of Zambia has failed to do that, and it can be seen from the continued attacks that are taking place. Your Excellencies, as far as that is the case, the state of Zambia has failed in its obligation to protect the right to security of the person.
Council, if I can just interrupt you, if I could take you to the facts. You suggest that the state of Zambia has failed to curb the killings, yet according to the facts in paragraph 8, the killings have, as a result of the setting up of these temporary shelters, been reduced to only 10 a year. That doesn't seem to correspond with your suggestion that they've failed to take steps. They have taken steps. I mean, they've set up these shelters and they seem to have had some impact. Can you please address that? And to what extent you still submit that they've failed to take due diligence to take steps to curb the killings?
Much obliged, Your Excellency. The argument of the applicants remains in the sense of the facts in issue. There are children under the age of 10 that have been taken away from the community into those temporary shelters. On the other hand, it is the submission of the applicant that we still have women with disabilities. We still have the elderly with disabilities out there that remain in the very same conditions that they were in before the children were taken away. So in as far as the rest of the population of persons with albinism is concerned, the government is not doing enough. Simply removing children from the community has not actually resolved the issues that are within the community. So, Your Excellencies, for the rest of the population of persons with albinism, the state of Zania is not doing enough to curb the violence.
So, what do you suggest to be enough? When you say the state has taken children to the shelter, don't you think preserving a young life is better than what you're quoting to say they are elderly people? So I don't see your comparison coming out clearly. Could you explain to this room that why are you saying children should not be taken to the shelter?
Your Excellency, thank you very much for the question. In terms of treating the different scenarios that you've raised, we have children on one hand, but then we still have women, as I said, on the other hand. And the line that has been drawn by the state of Zania, Your Excellencies, is arbitrary because under international law, a child is someone who is under the age of 18, and therefore, even to argue that the children are being protected is an understatement, is an overstatement, because actually most of the children are actually living outside the camps by the definition under international law, because it's not someone who is under the age of 10 that qualifies to be children only. Persons who are under the age of 18 qualify to be children. So within the communities as well, there's still children that are there. But at the same time, we'd like to address this court to say that the issue of the elderly and the women, Your Excellencies, the rights of the child and the rights of the women, for example, or anyone above the age of 10, should not be taken to be different. The right to life in this case remains the same. It doesn't matter if somebody is 20, for example, or 30. The right to life remains the same, and therefore the state still has duty to protect the right to life of those persons outside those camps.
Council, I will allow you 2 minutes to finish your submissions.
Your Excellencies, quickly moving on to the last issue, it is the submission of the applicant that the state of Zania is in violation of Article 5 of the African Charter concerning the right to dignity. In stating that, we would like this court to be persuaded by the reasoning of the African Commission in the case of Prince versus South Africa, in which it was stated that in looking at the right to dignity and how that right is violated, the principle is to look at the effect of a treatment or an action on an individual or a group of individuals. The question that should be asked should be, is an individual, will an individual feel less worthy because of an action that has been taken? Will an individual feel devalued, marginalized, or ignored because of an action by a state? Your Excellencies, the facts in paragraphs 4 and 8 of the facts in issue indicate that the state of Zania was reacting to a report that showed that there was a higher number of persons with albinism in the state of Zania as compared to the rest of the sub-Saharan countries. In reaction to that report, the only thing that it did, the state of Zania, was to bring out OCA1 genetic testing. And in doing that, it stated that it wanted to give parents a chance whether to have children with albinism or not. And in also doing that, it went on to the radio stations. It went on electing billboards concerning the same message. Your Excellencies, I would like you to go with me to the state of Zania. Imagine a person with albinism walking in the street of Zania and then seeing a huge billboard which is actually questioning his very existence by asking parents to actually choose whether to have children with albinism or not. At the end of the day, such a person with albinism will feel that they are less worthy of a human being, and therefore, by that feeling, their dignity will be affected negatively, and therefore it is our submission that the state of Zania has violated the right to dignity.
Maybe, Council, you've just asked the court to imagine something, and don't think that is very possible. Just one question. Can you simply clarify that in the line of the stipulations of the CRPD?
Your Excellency, thank you very much for your question. One of the principles of the CRPD concerning disability is the respect of disability as part of humanity and human diversity and humanity. And therefore, the issue is not to prevent people from being born, but rather to respect them when they are born and then to treat them on an equal basis with others. And therefore, when the state of, as the state of Zambia is trying to prevent the birth of these persons with albinism, it is our submission that it is in violation of the right to dignity in that respect. Seeing my time is up,
30 seconds, and we won't ask you questions, I promise.
All right. Your Excellencies, it is the prayer of the applicant that the state, the court makes a declaration that the state of Zambia is in violation of the right to protection of family life, as well as the right to be included in the community. Secondly, a declaration that the state of Zambia is in violation of the right to education. And thirdly, that the state of Zambia is in violation of the right to life, as well as the right to security of the person. And lastly, that the state of Zambia is in violation of the right to dignity of the person. And the applicant is asking this court to make two orders. Firstly, an order that the children that are that are in the temporary shelters should be brought back into their communities. And secondly, that the state of Zambia should review the laws that are surrounding the persons with albinism within the state. Much obliged, Your Excellencies.
Thank you very much, Counsel.
If it may please this honorable court, I'm Aaron Joel Kaleba, first respondent, first counsel for the respondent in this matter between Zambia Albinism Forum versus the state of Zambia. Your Excellencies, for purposes of clarity, the respondents recognize that this court has the necessary jurisdiction to hear this matter, and we shall not contest that issue. On the question of admissibility, the respondents still recognize that this matter is duly admissible before this court, and we do not intend to contest that issue. Your Excellencies, I will use 15 minutes of this court's time to respond to issue A and issue B as submitted on by the applicants. Your Excellencies, on issue A, I will contend that the removal of the children from their communities was not arbitrary and as such did not violate their right to family and a right to community. On issue B, Your Excellencies, I will contend that the providing of education to these children in these temporary facilities did not violate their right to an inclusive education. Your Excellencies, I will now proceed to my submission. On the first issue, the applicants have submitted that the removal of the children from their communities and placing them in the temporary facilities violated their right to family, their right to a community, and as such was arbitrary. In responding to that submission, I'll first contend that this action was not arbitrary and as such did not violate these rights. I'd like to draw your attention to paragraph 7 of the facts, which clearly states that the state of Zambia and within these communities, there was historic stigmatization and discrimination that persons with albinism faced. And as such, young children were particularly vulnerable to mutilations and killings. Your Excellencies, paragraph 8 of the facts further shows that the state took these children into these protective centers, and as a result, the number of persons killed has decreased. In that regard, and on that basis, it is the contention of the respondents that the removal of the children was not arbitrary. It was premised on the provisions of the Children's Act, as paragraph 9 of the facts will show, that the state had an obligation to remove the children from places of danger and put them in protective custody until the danger stemmed. Your Excellencies, the actions of the state were done in the best interests of these children.
Council, while the actions of the state may not have been arbitrary, were there the least invasive measures that could have been taken? Were there not other measures that could have been taken? For example, deploying police personnel into the relevant communities. Was this not a drastic action to have taken on the part of the state? If you could address the court on that, please.
Much obliged, Your Excellency. In response to your question, I'd like to ask this court to take into account the peculiar circumstances of this case. As already alluded to, paragraph 7 of the facts will indicate that there's a historic discrimination within these communities. The African Commission, in the case of Prince versus South Africa, has noted, on the basis of the principle of margin of appreciation, that the Commission should take into account the responsibility and the fact that the state is better placed to address rights violations within the community because it knows the situation and can thus determine which mode of addressing the rights violations to take. Your Excellencies, in that regard, we are aware, under the Convention on the Rights of Persons with Disabilities, Article 8, that there are other measures that we could have taken. However, because of the peculiar circumstances of this case, there was a huge risk on the rights of these children. They are segregated within their communities, within their own families. Therefore, immediate and effective measures had to be taken to guarantee the rights of these children. Your Excellencies, the right to life is inherent and is inviolable, and the state is required to take speedy, effective measures to protect the right to life of children, as Article 6 of the Convention on the Rights of the Child prescribes. Your Excellencies, in that regard, the state in its actions acted in the best interests of these children. We know that there are other methods that could have been done, like providing the police within these communities. However, on the basis of the discrimination within the communities, such steps would have impeded the achievement of the goal to secure the right to life of these children. Your Excellencies, I'll quickly like to draw your attention to the report of the United Nations Human Rights Commissioner that was published in 12 September 2013 that noted that children with albinism face a threat even within their families. These children are sold by their own fathers, by their own mothers. These children are sold off by their own relatives. In that regard, the state had to take the best interests of these children at heart and take into account that even within their families, there is no safety. Your Excellencies, I'll further draw your attention to the statements that were made by the independent expert on the rights of persons with albinism on 10th November 2016, where she alluded to the fact that states should take into account the need to provide iron bars to families in rural areas and to provide cement to families to guarantee the protection and the security of these persons. Your Excellencies, I cite these statements to show how unsafe the communities are, how unsafe the families of these children are, and how it was necessary to take these children into these protective centers in order to guarantee their right to life and protection and security, because that is the first priority of the state. The country is proceeding, and the children are the future generation. Today, I will not be around, the bench may not be around, but we need to benchmark and protect the rights of these children.
Okay, so, Council, are you suggesting that this should be the permanent solution in a state like Zania?
Much obliged, Your Excellency.
And we're creating a mini apartheid?
Much obliged, Your Excellency. In response to your question, I'd like to draw your attention to paragraph 9 of the facts, which indicates that the removal of these children from their communities is not permanent. It is only a temporary measure. The children are returned to their communities once the violence is tamed. This is not the only measure that the state is taking to address these rights. The state, under paragraph 3, has first of all taken legislative measures to address the various rights violations by signing, ratifying, and domesticating the the Convention on the Rights of Persons with Albinism. Your Excellency, there is no country in Africa that has done this. In that regard, the state is applying a multi-pronged approach to the issue of rights of persons with albinism.
Council, would you supply this room with the statistics? In your opening statement, you said, by taking the children to the shelter, the killings decreased. So are you talking of a scientific statistics, or can you supply us with those figures?
Much obliged, Your Excellency. In my opening statement, I alluded to paragraph 8 of the facts that shows that by taking the children into the protective centers, according to the police investigations, the number of persons with albinism killed every year reduced by half. Paragraph 8 of the facts, Your Excellency. Your Excellency, I'd like to proceed.
Sorry to Council to interrupt you once more, but this is a burning question. You mentioned that these facilities are only temporary. But Council, according to my understanding of the facts, these children have been in these camps since 2013, and it's 2016, so that's 3 years already. That's how long is temporary? Thank you, Council, if you could address us.
Much obliged, Your Excellency. In response to your question, I'd like to first of all draw your attention to paragraph 7 of the facts, that will note that these people have historically suffered discrimination. I'd also like to draw your attention to paragraph 5 of the facts that will also show that persons with albinism have also historically faced insecurities with their life, education, and health. Your Excellencies, the other steps that have been taken by the government are gradual. And because they are gradual, they are addressing an issue that is historic. Because it is historic, it will take time to be resolved. The state cannot take the risk of taking these children back into the communities when it knows that their right to life will not be guaranteed. We cannot make that mistake. The right to life of these children is a priority of the state, and we shall do everything to guarantee its protection.
Maybe Council, are you suggesting that because there are measures being taken, it will be okay for these children to remain in the shelters, even if that time is 100 years, just because people have been historically discriminated?
Much obliged, Your Excellency. In response to your question, no, that is not my submission. The state is taking other measures in conjunction with this step of taking these children into the protective centers. And as such, we are positive that within a short period of time, we shall be able to return these children to their communities. In that regard, Your Excellency, the applicants have...
Sorry, Council, said that you are positive of your measures, positive because of the way you perceive, or positive because of the empirical way in which we can get the results of these measures?
Much obliged, Your Excellency. We are positive in regard to paragraph 8 of the facts that will show that the killings have reduced because we have taken these children into these protective centers, which means that we are looking in the right direction, coupled with the multi-pronged steps that we have taken, we shall achieve the goal. Your Excellencies, in that regard, it is our contention that the right to family and the right to community has not been violated by the state. These rights are subject to progressive realization as Article 2, Sub-Article 1 of the Convention on the Economic, Social, and Cultural Rights provides. Your Excellencies, in the present circumstances, as I have alluded to, because of the threat in the communities, the children, it was necessary to take...
Just a small clarification. Did you say the right to family is subject to progressive realization? Does the principle of progressive realization apply to all rights?
Much
If
obliged,
you
Your
can just
Excellency.
answer that question, and then we will allow you to proceed with your submissions without any more questions.
Much obliged, Your Excellency. The principle of progressive realization applies to economic, social, and cultural rights as General Comment number 3 of the Committee on the Convention of Economic, Social, and Cultural Rights has noted. Your Excellencies, in that regard, because the children were taken into these protective centers, the state knows and acknowledges that rights are indivisible, interrelated, and interdependent. And as such, we have taken positive steps to guarantee that these rights are observed. Paragraph 9 of the facts will show that children below 5 were allowed to come with their parents to the community, to the protective centers, and will also show that the state has taken positive steps to ensure that these children are returned to their communities once the violence has stemmed. Your Excellencies, pursuant to Article 60 and 61 of the African Charter, we would like to cite the case of Airy versus Ireland persuasively, decided by the European Court on Human Rights. In that case, the court decided that liability should only be imputable on the state for failure to take positive steps. Your Excellencies, paragraph 9 is sufficient to show that the state is taking positive steps to guarantee the fulfillment and the observation of these rights. Your Excellencies, briefly on issue 2, on whether the right to an inclusive education has been violated, it is our contention that we are alive to the fact that children must receive an inclusive education as guaranteed by Article 28 of the Convention on the Rights of Persons with Disabilities. We're also alive to the fact that an inclusive education is subject to progressive realization as Article 28 of the Convention on the Rights of the Child notes. However, as earlier alluded to under issue A, because of the threat of the right to life of these children in their communities and the historical insecurities with the education that they have faced, as paragraph 5 of the facts will show, the state took steps to place these children in its protective centers. However, because the state has an obligation that it must fulfill, we have ensured that we have to provide education to these children in line with the minimum core obligation. Your Excellency, General Comment number 3 on economic, social, and cultural rights has enjoined state parties that even when these rights, such as the right to education, are subject to progressive realization, the minimum core obligation must be met. Your Excellencies, the state has taken these steps to ensure that even when in these protective shelters, these children have the right to an education and that they receive this education. Your Excellencies, in that regard, we contend that providing education to these children was not discriminatory. And in that regard, I would like to cite the case of Moot and another versus Fencing Center, pursuant to Article 61 of the African Charter, decided by the Industrial Court of Botswana. The court held that not all forms of differential treatment are unfair. Some of these forms are done to give life and for the purposes of fulfilling certain legislations. Your Excellency, providing education to these children was done to fulfill the purposes of the Children's Act that enjoins state parties to take children into protective centers when their life is threatened. It is thus our submission, Your Excellencies, that the right to family, the right to community was not violated by the state, and that the taking of the children into these protective centers was not arbitrary, and that providing education in these protective centers did not violate their right to education and was not discriminatory. If I may be of no further indulgence to this court, I will let Second Counsel proceed.
Good afternoon, Your Excellencies. If it may please this honorable court, I'll reintroduce myself. My name is Atim Miriam Okeno, appearing as second counsel for the respondents, the state of Zania. In this matter, the Zania Albinism Forum versus the state of Zania. I shall spend 15 minutes of this honorable court's time deliberating upon issues C and D in response to the applicant's submissions. Your Excellencies, the respondents aver that the state of Zania has not violated any human rights with regard to failing to bring a halt to the killings and mutilations of persons with albinism, subject to the right to security of persons and the right to life. And secondly, that the state of Zania in the promotion of Okawan genetic testing has not violated the right to dignity. Rather, it has promoted the right to sexual and reproductive health rights. If it may please this honorable court, I beg to proceed.
You may proceed, Counsel.
Much obliged. First and foremost, the state of Zania would like to bring to this court's attention that it does not condone any forms of human rights violation with regard to the interests of persons with albinism. Your Excellency, with regard to the right to security of persons as provided for under Article 14 of the Convention on the Rights of Persons with Disabilities and Article 6 of the African Charter on Human and People's Rights, the respondents would like to contend the applicant's submissions that the state of Zania has not undertaken the necessary measures to ensure that the acts of violence effected towards persons with albinism, as stipulated under paragraph 7 of the facts, have not been undertaken. Your Excellencies, pursuant to the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe, where it was noted that liability is imputable onto the state, the respondents further would like to draw this court's attention to the fact that the court also noted that for the complainant to ensure that this burden is placed on this liability is placed on the state, it ought to prove that the state condones the pattern of abuse through pervasive non-action. Your Excellencies, pursuant to paragraph 8 and 9 of the facts, the state has undertaken several measures to ensure that persons with albinism enjoy the right to security of persons as well as the right to life. The applicant submitted that the state of Zania has failed to provide effective prosecution for persons who engage in violent activities towards persons with albinism, as well as the fact that the state of Zania is implementing an outdated Witchcraft Act. Your Excellencies, the respondents have taken note of the fact that the Witchcraft Act indeed is ineffective. As such, pursuant to paragraph 3 of the facts, the state of Zania has undertaken further steps to ensure that it ratifies and domesticates the Convention on the Rights of Persons with Disabilities, as well as the African Charter. Your Excellencies, I would like to allude to the fact that not only has the state of Zania domesticated these treaties, it has gone ahead to ensure that the elements within the CRPD as well as the African Charter are included in the Bill of Rights. It's for this matter, therefore, that the Bill of Rights within the Constitution of the State of Zania complements the Witchcraft Act and as such provides for effective prosecution of persons who engage in violence effected towards persons with albinism.
Sorry, Counsel, just one small clarification. You mentioned that these treaties have been domesticated. Please, can you show us where exactly in the fact?
Paragraph 3 of the facts, much obliged, Your Excellency. Paragraph 3 of the facts alludes to the fact that the state of Zania has ratified, domesticated the Convention on the Rights of Persons with Disabilities, as well as the African Charter, and it has gone ahead to include these aspects within the Bill of Rights of the Constitution of Zania.
You've just stated that the Witchcraft Act is ineffective, and you are contending that because of the Bill of Rights, maybe the weaknesses of the Witchcraft Acts have somehow been cured. Can you clarify that?
Much obliged, Your Excellency. By virtue of the fact that the Convention on the Rights of Persons with Disabilities, as well as the African Charter, has been implemented within the Bill of Rights of the Constitution of Zania, it's to the effect that the rights and interests of persons with disabilities, including the rights and interests of persons with albinism, is of paramount interest to the state of Zania. By virtue of the fact that the Bill of Rights is the paramount law within the state of Zania, implies that the rights and interests of persons with albinism cannot be disregarded. Your Excellencies, in response to the applicant's submissions that the rights to children and that of women should not be looked at differently, the state of Zania submits that not only has it undertaken legal steps to ensure that the legal framework and the legal environment is accommodating with regard to the rights and interests of persons with albinism. It has also gone ahead to provide free optometric testing as well as free sunscreen lotions as intimated under paragraph 9 of the facts. This is to allude to the fact that other persons living with albinism are not disregarded, and not just children, as was submitted upon by the applicants. Nevertheless, we cannot disregard the fact that the placing of children in protective custody by the state, as stipulated under paragraph 8 of the facts, has created a positive impact within the society of Zania. Paragraph 4 of the facts intimates that 20 persons with albinism were killed annually. This number, however, reduced to 10 people with albinism being killed annually as intimated in paragraph 8 of the facts. It is for this matter, therefore, that the state of Zania has ensured that it has undertaken necessary steps. Pursuant yet again to the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe, it's important therefore to note that it has undertaken the necessary due diligence to ensure that the rights and interests of persons with albinism are not disregarded. Nevertheless, the respondents would like to make it clear to this honorable court that the state of Zania does not intend to stop here. The state of Zania intends to effect other measures in order to ensure that the rights and interests of persons with albinism are protected, and that some of these measures, for example, the aspect of placing children into protective custody, were interim, and these were in line with the report as conducted by the Medical Research Council of Zania in conjunction with the applicants to curtail the killings of persons with albinism. It was an interim measure, and thus the state of Zania does not intend to stop here. It is therefore our submission that the state of Zania cannot be held liable for the rights and killings, cannot be held liable for the violation of the right of security of persons, as well as the right to life. Your Excellencies.
And so, how do you respond to applicants' argument that the state can actually be held liable for actions of private actors and that you should have done something to stop the killings?
Much obliged, Your Excellency. It is true that the state of Zania can be held liable for the actions of private actors with regard to the right to security of persons. Pursuant to General Comment number 35 of Article 9 of the International Covenant on Civil and Political Rights, which equally provides for the right to security of persons. It is our submission, however, that the state has undertaken necessary measures to ensure that the rights and interests of persons with albinism with regard to security of persons is protected. Nevertheless, the state has also gone ahead to ensure that the livelihood of persons with albinism is protected through the provision of free sunscreen lotions as well as optometric eye testing. Pursuant to the decision of this honorable court in Sudan Human Rights Council versus Sudan, where it was noted that the right to life ought to be provided a broader interpretation, it is our submission that the state of Zania, through the provision of free optometric services as well as free sunscreen lotions, has also endeavored that the right to life of persons with albinism is indeed protected. If it may please this honorable court, I'd like to proceed to my second issue.
Proceed, Counsel.
Much obliged, Your Excellency. With regard to the aspect of the right to dignity, as well as the fact that OCA1 genetic testing intent was discriminatory, as submitted upon by the applicants, the respondents contend that the promotion of OCA1 genetic testing, as provided for under paragraph 11 of the facts, was in light of Article 25 of the Convention on the Rights of Persons with Disabilities. Article 25 of the Convention on the Rights of Persons with Disabilities, which provides for state parties to ensure that the right to the highest attainable standard of health is provided to its people, also connotes that health services should include early identification and intervention as appropriate services designed to prevent further disability. Your Excellencies, the OCA1 genetic testing that is promoted by the state of Zania is not to discriminate on the rights and interests of persons with albinism. Rather, it's to provide a forum where persons within the state of Zania can reach informed decision-making with regard to their sexual and reproductive health rights.
Council, sorry, there are many other diseases which have genetic implications. For example, breast cancer, which could be tested via genetic testing. Why single out this particular test, this particular category? That does, for me, suggest that there's perhaps an alternative purpose. And the other question I would like to ask is, does this is not going to prevent any disability? What is the preventative purpose of this test? It's not going to prevent any, certainly in respect of the people who are already alive and walking around and who are with us. I don't see any preventative purpose of such a test. Thank you.
Much obliged, Your Excellencies. With regard to your first question as to why OCA1 genetic testing, why albinism, Your Excellencies, by virtue of paragraph 4 of the facts, which intimates that 1 in 2,000 people within the state of Zania are facing the condition of albinism, Your Excellencies, the promotion of OCA1 genetic testing as stipulated under paragraph 11 of the facts, it portrays a state that is willing to deal with the issues within its country. Your Excellencies, in comparison to a state with a population of 55 million people, as intimated under paragraph 1, the ratio of 1 in 2,000 people suffering with albinism indeed is high. As such, OCA1 genetic testing is not only dedicated towards preventing the condition, but also as a means of awareness.
So, yeah, I'm reminded here there were 2 questions, but just wanted to stress on that. So, are you implying that it will be okay for people to proceed with abortion if they know that they are about to give birth to a child with albinism?
Much obliged, Your Excellency. In response to your question, I would like to draw this court's attention to Article 17 of the UNESCO Declaration on the Human Genome and Human Rights, which I cite persuasively pursuant to Article 60 of the African Charter, and to the effect that states should respect and promote the practice of solidarity towards individuals, families, and population groups who are particularly vulnerable to conditions and diseases of genetic character. The submission of the state is that the promotion of OCA1 genetic testing, first of all, will provide an opportunity for persons who are most likely in a detrimental position with regard to aspects that deal with genetic issues, in such that it provides them an opportunity to make decisions. Paragraph 11 of the facts intimates that the OCA1 genetic testing will the results of the OCA1 genetic testing is subject to the persons who commit themselves to such testing. Whether or not the parties decide to keep the children or not is up to them. However, it is in light of sexual and reproductive health rights as provided for under Article 14 of the Maputo Protocol. It's to the effect that the enjoyment of the right to the full enjoyment of the right to sexual and reproductive health rights upholds the element of informed decision-making. By virtue of the fact that...
Sorry, Councillor, just very quickly. At the core of sexual and reproductive rights, which you keep referencing, is a choice, is a right of choosing. And this means that some children with albinism are going to be born, okay? It seems to me that this decision to promote OCA1 testing is a smokescreen or a type of cover-up, or let's just be fair and say it seems to be evading the issue, which is the protection of those who are alive. And this is relating to the question that came from my colleagues. So knowing for sure that this testing is actually not going to completely eliminate people with albinism in the community, why is the emphasis then not, why don't you put your entire energies on what seems to be the case, the context here, which is the situation with witchcraft and the situation of attacks? That seems to be more of the long-term solution, since people with albinism are going to be born anyway.
Councillor, just a little bit of guidance. I think you have 2 questions that are yet to be answered. The last one that was paused and one of the very first ones that was paused. So I'm going to allow you 3 minutes because you've actually run out of time. 3 minutes to answer the 2 questions as well as finish your submissions. Thank you.
Much obliged, Your Excellency. With regard to the last question, Your Excellency, I would like to draw this court's attention to Article 1 of the SADC Gender Protocol, as well as Article 1 of the Convention on the Elimination of All Forms of Discrimination Against Women. And it defines discrimination. It's to the effect that discrimination shall amount to any activities that impair the full enjoyment of human rights and fundamental freedoms. Your Excellencies, the promotion of OCA1 genetic testing does not limit the enjoyment of human rights. Rather, pursuant to the World Health Organization's statement on human genomics in public health, it provides information. It provides information for parties to make decisions. Your Excellency, the promotion of OCA1 genetic testing shall also amount to the underlying aspects of promotion of such genetic testing. That includes the advantages, the disadvantages, as well as what to expect of such results with regard to the tests that are being conducted. Your Excellencies, it's our submission, therefore, that the state of Zania has not violated any fundamental human rights with regard to the promotion of OCA1 genetic testing. We pray, therefore, that this Honorable Court, pursuant to Article 27 of the African Court Protocol, declares and adjudges that the state of Zania has not violated any fundamental human rights and thereby dismisses this case accordingly. If I may be of no further indulgence to this Honorable Court, I beg to rest my case.
Council, just a small confirmation. Was the question answered?
Council, I don't know if you can take my question any further. The second question, which was the extent to which or in what way this testing is actually assisting in alleviating any form of disability, given that the people whom the tests are being conducted on are people who are already alive, living their lives. There doesn't seem to be, to me, to be any medical assistance that this test actually provides to those people, and hence what the purpose of the test is.
Much obliged, Your Excellencies. With regard to your question, I would like to draw back to our submission, which is that the promotion of OCA1 genetic testing can also be a form of awareness. In the promotion of OCA1 genetic testing, it also alludes to what to expect, what to expect, what not to expect, how to deal with the condition, and as such, it provides an avenue for these persons to...
Sorry, Council, just to interrupt you, not because I don't want you to have to repeat all of the submissions that you've already made. So are you saying that there isn't necessarily any specific purpose other than awareness building in relation to these tests?
Our submission is that other than awareness, the promotion of OCA1 genetic testing provides an avenue for the full enjoyment of sexual and reproductive health rights.
Thank you, Council. You're excused.
Much obliged.
Applicant, do you wish to rebut?
Thank you, Your Honorable Judges. The state stated that the state used bad circumstances as a justification for removing children from their homes, but I'd like this court to note that the African Charter does not have a specific restriction clause, and it was said in the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe that states can't use emergency situations to justify violating rights. Secondly, the state of Zambia also said that the moving children was in their best interest, and I'd like to submit to this court that the principle of the best interest was said in General Comment number 14 to be aimed at the full and effective enjoyment of human rights and holistic development. The state failed to consider the psychological trauma caused when ripping children away from their families and the social impact it would have on the children. Also, the state stated that right to family was subject to progressive realization, and we'd like the court to note that Article 17 of the ICCPR provides for the right to protection of family and the home, and as such, it is a civil and political right and not subject to progressive realization. Also, Your Honors, the state seems to have forgotten that there are 3 minimum core obligations with regards to inclusive education, and not just the one that they seem to have accomplished. Your Honors, we'd also like the court to note that there's a difference between domestication of treaties and modeling one's legislation after the treaties. And the state, according to the facts, has not domesticated their treaties. Therefore, there's still a gap in the domestic legislation of the state, and the state has failed, therefore, in that regard. The state has also failed to address this court on the failure to compel witnesses, as was said in the case of Paul and Audrey Edwards versus the UK. The state has a duty to compel witnesses in cases where there are grave violations of human rights. And I'd also like the court to state that the applicant's report recommended that the state undertake research to explain higher prevalence. The genetic testing of OCA1 doesn't provide any information that would help the state explain prevalence. And the right to choose whether to have children is the right to choose whether or not to have children, not the right to choose whether to have children with albinism or not. Thank you, Your Honors.
Thank you very much, Counsel. The bench is now going to adjourn, and we will get back to you. Thank you.
The judges will take 15 minutes to deliberate and then they will return. Thank you.